Questions for the gentleman? I don't see any. Thank you for that presentation, and we're going to be assigning that legislation to, I'm not sure, our sales tax subcommittee. Yes, sir. I had it out of numerical order here. That would be Chairman Mills, Chairman Martin Scott, Chairman Don Parsons, or Chairman David Knight. I would encourage you to go ahead and get a hearing arranged as quickly as possible and get that back to the big committee. Thank you for your presentation.
Thank you, Mr. Chairman. Thank you all.
Anyone else in a hurry?
I'm just whenever you want.
You feel real good about it, do you? I'll remind me and everybody else these things are on the internet for everybody back home to see, so I've shown amazing restraint, Representative Anderson. But we're delighted to recognize you, sir. If you would, please come forward and tell us about your House bill. Is it 975?
Mr. Chairman, you have a substitute bill. It's 975, but you should have the substitute bill in your folders.
Do you have an LC number on the sub?
LC 188825S.
Yes. It's in your folders, members of the committee. It just might not be in order. Okay, you recognize. Tell us about it.
Mm-hmm. Simply what this bill is where all new spec homes that are built would the ad valorem tax would be exempt until it's actually sold, leased, or rented. All spec homes, and it would. We realize it would be an exemption. It would have to be a statewide referendum, but this was brought to my attention from the home builders associations and also the bankers, to where try to save some jobs, and also that the home builders, the spec home is not requiring no services. The lot would also be taxed on the ad valorem tax as an empty lot until actually the home is sold or leased or rented.
Okay, it's an interesting proposition. Does anybody have any questions for Representative Anderson? I see 124. That's Representative Powell.
Representative, would this be retroactive to existing homes or just homes built after this date?
Both new homes after this bill passed.
And Representative Black.
Will this apply to homes that's under construction?
After the bill is passed, after it's passed, yes.
Have you got provisions in there? One of the thoughts that occurred to me is somebody that a developer goes out there and maybe digs a foundation and says he started construction, and then leaves it sitting there so he won't have to pay taxes on it until he decides to move forward. I mean, I think you need to have it crafted so you won't have someone taking advantage of it.
I understand. Thank you, sir.
As always, it seems the devil's in the details, isn't it, Representative Black? 17, I'm sorry. Is that? Okay. Representative Bryant.
Yes. Representative Anderson, you did state that this is only spec homes.
Right.
And that taxes will still be being paid on the lot, on the land itself.
As an empty lot, correct.
Okay.
I have a question, and then I'll go to whoever number 10 is. Can you point to me in the bill where we talk about a spec home? Spec has a meaning to me
Well,
that it's really not a pre-sold, for instance, as opposed to a pre-sold.
That's my little language, Mr. Chairman, but
I think the definition of single-family residence is eligible single-family, which is already in the code.
yes.
I'm not sure. Is it your intent to have it only on speculatory listings, or is it on all?
All new
Single-family.
homes that's not calling for no services from the county or state or any form of government, and that until life is actually in that home, till we have someone buys it, rents it, or leases it.
I expect there might be a lively debate on this moving forward. It's over, and I commend the gentleman. Number 10, who is that? Representative Flood?
Yes, thank you, Mr. Chairman. Representative Anderson, part of what I read on page 2 is with regard to a certificate of occupancy, and that this exemption would not apply until after there was a certificate of occupancy. Would that then not mean that until the house is sold, there wouldn't be a certificate of occupancy issued anyway?
It's supposed to be to the point to where even if a developer, builder, contractor rented it or leased it, they would start paying ad valorem tax at that time.
Okay. All right. Thank you.
Yeah, it's good to see an old friend, Representative Stacey Abrams.
And thank you, Mr. Anderson. I think you may have answered my question through Representative Flood's question, but do you intend for certificates of occupancy or contracts? So let's assume that the house is under contract and could remain under contract for an indefinite period of time. Would you consider that a speculative home, or would you consider that to be a home that would be eligible for the tax exemption? And maybe that's just something to consider, because I do think that you've got a fair range of real estate opportunities that aren't exactly captured by sold or otherwise occupied, because in between there are tax lawyers who come up with really interesting things to do. So,
I'd be glad to amend it to where it'd be a time limit on a type of contract like that, and be glad to get with you and add that to it.
Thank you.
Thank you.
Thank you for those comments. I don't see any further questions. We'll be assigning that Representative Anderson to our ad valorem tax subcommittee. That would be Chairman Speak, Roger Williams, or David Knight. I would encourage you to go ahead and get some hearings set up, and I expect that to be an interesting debate. We thank you very much.
Thank you, Mr. Chairman.
Glad to have you.
Thank you so much.
We have a real honor to have somebody I don't believe has ever been to Ways and Means since I've been here, but this is a day that will just I'll cherish in my memory forever. We've got one of my very best friends in the whole world, and somebody I admire greatly, Representative Butch Parrish, or Larry Butch Parrish. And we're honored to have you here, sir, to tell us about House Bill 1020 and House Resolution 1203. You can choose whichever one you want to go first.
Is this all right here, Mr.
Yes, sir,
Chairman?
wherever you're most comfortable.
Well, thank you. First of all, let me say I'm not an attorney and I'm not a tax expert, so I just want to make that clear before I ask you to consider these two propositions. Mr. Chairman, thank you for allowing me to bring this to the attention of you and your committee. Ladies and gentlemen, all we're asking for is just a very simple explanation of House Bill 1020 and then the companion legislation, House Resolution 1203, would simply give flexibility to our school systems in how they could spend their ELOS money. As you all are aware right now, the 1% tax or ELOS is levied by the local boards. It's for a specific period of time, not more than 5 years. And it has to be spent for specified capital projects. And then it can only be levied after a referendum is approved. What I would propose to you is that in House Bill 1020, that we give some flexibility to our local school systems as to how they could spend that money. And that they could continue to spend it for capital projects, just as they're doing now, or they could spend it for maintenance and operation in the educational system, or a combination of the two. The same restrictions would be in place, a specific period of time, the 5 years, and then that it would require a referendum. And Mr. Chairman, what brought this to my attention in my home county we're not having the growth that, say, a Gwinnett County has or something. And they've gotten their school system, their facilities in pretty good shape. But what they could use some help with, not necessarily building new buildings, but maintaining and operating the system that they have. And all this would do would simply allow them the flexibility, continue doing exactly what we're doing, or it could be spent on maintenance and operation, or a combination of the two.
Would the gentleman yield?
Yes, sir.
Vice Chairman Sims.
Mr. Chairman, I was just going to ask, you realize when you do M&O, that would mean that you would be able to use this for salaries. Is that also a part of the plan with this?
I think that the local system probably can best determine how they could use that money to get the biggest bang for their buck than we could tell them up here.
Representative Stevens, you recognize, sir?
Representative Parrish, good afternoon.
Thank you.
Although that's noble, I'm thinking in terms of my school district, where we just passed East Floss, and it should generate about $66 million. But my concern is for major school district is that everybody's not going to get a piece of that pie if we open that can of worms. Simple fact is that if you look at the money allocated in the East Floss now that we passed, a certain segment of our school district is not going to get a penny of it, not 1 cent. And I'm concerned that we do have school boards who don't look at the whole picture for everybody, and that's my biggest concern. Although the idea is good, it's a very good idea. I just have some concerns about that. And I don't know if there's anything you can put in there or build in there to ensure that everybody's going to get a piece of that pie. I imagine a smaller district, it will work real well.
Well, I appreciate your concern, and I suppose that might be a problem in some places, but that school board is charged with spending that money, and I suspect if they don't spend it like they should, when they stand for re-election, the voters are going to tell them whether they approve of what they've done or not, just like they would tell us. And whatever happens on this proposed tax, it's still got to be a referendum has to be approved, or you can't do anything with it. So I understand your concern, but I believe there'd be some checks and balances there to maybe address some of those issues that you have.
I don't see any other questions. Representative Parrish, thank you for that presentation, and I think that's an excellent idea that's going to get a lot of debate, I'm sure. And we're going to assign that to our sales tax subcommittee, and that would be Chairman Martin Scott, Don Parsons, or David Knight, either of those three gentlemen. I would encourage you to, and I know you have many other responsibilities over in appropriations, but the quicker you can get into the subcommittee process, it's starting to get jammed up there a little bit. So
I sure will, Mr. Chairman. Thank you.
We're looking forward to a good debate on that. Now, are you going to tell us about House Resolution 1203 that goes with it? Or?
Yeah, well, yes, sir. It's just required that because it would be a constitutional amendment, we'd have to have the ballot to go with it, and the two would necessarily need to travel together, I think.
Okay, and it will to the sales tax subcommittee as well. We thank you very much for that presentation.
Thank you.
We look forward to hear more about it.
Thank you.
Is there anyone else? I think Representative Scott needs to go to another committee meeting. He told me earlier. If you recognize, please, sir.
Thank you, Mr.
Tell us
Chairman.
about House Bill 1029 or 1037, whichever one you want to choose.
Of my favorite committee. House Bill 1029 is very simple, and it abolishes the corporate income tax for the state of Georgia. It's approximately $580 million of the state's total revenue. If you listen to the cities, the counties, and the school systems, they tell us that there's approximately a 20% gap in what they believe is due in sales tax collections and what we're actually collecting. My intent is to, or I would hope, that we could take the people from the Department of Revenue that are currently working in corporate income tax, shift them to sales tax collections, and hopefully offset the majority, if not all, of the loss of revenue by picking up a significant portion of what we believe to be the uncollected sales tax. The other aspect of it is what it does for our economy. Think about the message that we send to the rest of this country and the world that Georgia means business if we abolish the corporate income tax in the state of Georgia.
Any questions? I don't see any. We're going to assign that, Representative Scott, to our income tax subcommittee.
Thank you,
That
Mr.
would
Chairman.
be Chairman's Mills, Peak, or Knight. Either of those three gentlemen can give you a hearing on that at your earliest convenience.
Thank you.
Go ahead, sir.
Ladies and gentlemen of the committee, the second bill, House Bill 1037, simply reduces the capital gains tax from 6% to 3% in the state of Georgia.
Any questions? We will assign that as well to the income tax subcommittee. We look forward to hearing a lively debate on both of those.
Thank you, Mr. Chairman, and I'm going to go back to appropriations.
Okay, thank you, sir. It's a real honor, too, now to have one of the nicest gentlemen up here. And to have him in the Ways and Means Committee is just an incredible pleasure. Terry England, or Representative Terry England, come tell us about House Bill 1006, please.
Thank you, Mr. Chairman. I appreciate those comments. This is my third at bat in your committee, and we're looking forward to it. Today we bring to you House Bill 1006, and basically it's just some clarification language to both help agricultural retailers and agricultural retail customers on clarifying the exemptions and getting a clarification from the commissioner on the exemptions through a exemption determination letter from the commissioner himself. So basically the commissioner would rule whether a customer would be exempt or not exempt.
25, is that Representative Black?
You won't comment on what factors the commissioner might be able to use in determining whether a person would be exempt?
We will, of course, work with them considerably, but there's always been a gray area both for the retail side and for the consumer side in this, and in the past it's been kind of hard to get a concrete answer one way or the other. And as a retailer and as a consumer both, there's always the potential of a liability, tax liability being out there that could accumulate to a fairly large number at some point. And so what we're looking here is to clarify those gray areas, ambiguities, or whatever, and through the exemption letter, because the retailer is required to keep on file a signed exemption letter from the agricultural producer, the one using the crop. And at this point, basically, the retailer is charged with making this decision themselves, and with nothing to fall back on.
Do you reckon it might be wise for us to come up with some criteria rather than leaving it to the discretion of the commissioner?
We can amend the bill whichever way the committee feels happy and strong toward. Yes, sir.
I think maybe you and I need to put a little thought into that.
We'll be glad to.
I think you both certainly have a strong background, and I look forward to getting the best information from both of you. Representative Knight has a question, if the gentleman will yield.
Mr. Chairman, I thought it was the other way around, that the purchaser had the obligation of doing the exemption, or saying that this was for the exempted purpose of.
The purchaser basically comes to the retailer and says, I'm raising yard chickens for sale. So then, therefore, it is the retailer's responsibility, or we feel that it's our responsibility, we take it as our responsibility as a retailer, then to make the decision whether the consumer is being truthful or if it's someone just trying to keep from paying sales tax. So at that point, then you try to decide if that person is going to be the end user of that product. If they're the end user of that product, then the sales tax liability does lie with them. If they're producing it to sell at a different market or to sell for further processing, then they are exempt.
Okay, we look forward to further debate on that issue, and it's something we're excited about considering here at Representative England. We're going to assign that to our sales tax subcommittee. That would be Chairmans Martin Scott, Don Parsons, or David Knight. Either of those three gentlemen can arrange a hearing for you at your earliest convenience.
Thank you, Mr. Chairman. Thank you for
sir.
your kind comments.
Thank you. Now, Chair recognizes the gentleman from Macon. Tell us about House Bill 993, Representative David Lucas.
Thank you, Mr. Chairman, members of the committee. I dread being here. Let me first say that. It's not a very easy committee to deal with, number one. I'm here on 993, and please let me explain this. I would like to leave something that, and so that committee can do it by committee substitute. In our haste to do it, that was a mistake I made on it. On 993 deals with the hotel motel tax that we have in Macon, and we levy 6 cents now. If you look at the bill you have, they got it at 5 cents, so they made a mistake. You got a copy of the new. All right. Well, under the current law, as we deal with the HMT, we amended a few years ago, and it lists the 5 things that you have to do, and then that penny thereafter is split half and half. We have what we call the Macon Bibb County Convention Bureau, which is the marketing arm for the money. We had some meetings, and the chairman knows how well about us and our delegation. We had a lot of differences last year. We finally got together after the city and the county got on us about it. And what the problem is, we were told that we need to raise money for the Halls of Fame. They are open certain days of the week that we had to put more money in, that it was cut. The city and the county passed a resolution asking for the increase up to 7 cents, but they wanted that 1 cent to go directly to the operation of the Sports Hall of Fame and the Music Hall of Fame, and then there's another Douglas Theater. It's part of that museum district. In trying to work with it, there were several options. Number one, you could go what they call a local option, which means that then the city and the county would have to reverse the ordinance that they already had in order to get do this new exception. We didn't want to change how our marketing arm was operating. So the only way we saw that we could do it, based on legislative counsel, because it's the law itself, to me, is kind of convoluted, Mr. Chairman. I think you need to take that thing and look at it real hard. But we operate under 48-13-51. The city of Macon and Bibb County operates under paragraphs 3.4 and 4. And what this will allow us to do, if we can amend this, it will allow us to raise that 1 penny for those halls of fame for that particular section. Now, there are several 6% parts within the code, but that is the one that we operate under. And to my knowledge, we are the only one that operate under 3.4 and 4. If you would allow us to do that, then we have to come back and pass 2 separate bills, just basically agreeing to what the county and the city have already agreed to do in their ordinance for what that penny is designed for. Now, I know there's a lot of conversation. I know there is opposition out there to it, because I talked to some folks last year about it and they were opposed to it. But we are here at the mercy of the state. This is the first time we've ever had to locally fund 2 state museums. Had to try to raise money to fund them. I'd be glad to answer any questions.
I don't see any right now, Representative Lucas, but that may be because you made such a good, comprehensive explanation of it.
I don't know if I can do that.
I don't mean that facetiously. I really don't.
Yeah.
But I'm sure there is going to be in subcommittee, and that's the process of this committee, and I'm going to assign that legislation to the Public Finance and Policy Subcommittee, and hopefully we can get a hearing arranged for you just as quick as possible. That would be Chairman Tom Rice, David Knight, or Chuck Martin. Either any of those 3 can arrange a hearing, and I would encourage you to go ahead and get started as quickly as possible, even though I know you're busy on a lot of other fronts. But I know it's important to Bibb County, I know it's important to Macon, and I know it's important to the state of Georgia that we get some, I guess, continuity in our tax code with this hotel-motel tax, because you're absolutely right when you say it's very much almost totally dysfunctional. I mean, it's very, very difficult to understand for even the best tax minds. So I applaud you on your efforts there, and we look forward to a good debate on that, and hopefully a resolution that will be good for all the people of Macon and Bibb County.
Thank you very much, Mr. Chairman.
Thank you, sir. Glad to have you. There he is. I'm sorry. Representative Lunsford, I didn't see you, sir. Come. You recognized, please, for House Bill 1038.
Thank you, Mr. Chairman. Actually, I was sitting there quietly to check the mood of the committee because you said if they were real anxious. I wanted to make sure everybody was jovial. But appreciate the opportunity to be here. 1038 is a pretty simple matter. What it does is it allows a tax credit for physicians who provide indigent care uncompensated. We originally dropped the first bill. Mr. Shore drafted it, and we'd asked your lead counsel to get a fiscal note. And the fiscal note came out unusually high, actually $67 million high. And so what we've done is we've rewritten the bill, and we've broken it into 4 steps. And then what we've also done is excluded physicians that actually are employees of medical care centers. And the reason for the bill, what we're trying to do, is we're trying to compensate the physicians. As you know from your brother, Dr. O'Neill, doesn't get paid for treating an indigent care in an emergency room. The hospital may receive DISH funding or disproportionate share hospital funds. The hospital may receive indigent care trust funds, but the physician himself is left out or herself is left out. So consequently, if you're 55 years of age and you're a doctor and you get a call and you're headed to the Fox Theater with your wife on a Friday night, over the age of 55, you're not required to show up at the emergency room because you have an age exclusion. So you got a $100 set of tickets. You're thinking, do I throw the tickets away? Do I go to ER where I'm never going to get paid? What we're trying to do is facilitate a method by where at least they get compensated for showing up with a small tax credit. It'll have a few impacts on it. It'll improve the staffing of our emergency rooms on off hours. It should actually attract doctors to our state because, to the best of my knowledge, no state offers a tax credit for indigent care to the physician himself or herself. And then the other thing is what we're trying to do is improve participation in your free clinics. Currently, we have our Good Samaritan clinics, as you know, in which case we hold the physician and the nurses harmless for providing care there, but there can be no compensation. This would kind of override it and say, you're not really receiving compensation, but you can get reimbursed at Medicaid rates up to the first year only $1,000 a year. But if you're giving away your time before, maybe it's a little bit of incentive to staff a few more hours at the free clinic. Because everybody that we see in a free clinic is somebody we take out of the emergency room or the hospital, which we're directly paying for. And so it was just, is it enough? Mr. Chairman, no, sir, it's not even close. But could we afford enough? And the answer is no, sir, we could not. But I think it's a good start to get there. It reduces the burdens on our hospitals. It improves the physician relationships, and I think it will improve staffing. And so that was the reason for the bill.
Great explanation. For the gentleman. Yield for question?
Yes, sir.
Representative Abrams.
Thank you, Mr. Chairman. Thank you, Mr. Lunsford. Just 2 questions. One is just because I don't quite understand how this works. You can be a physician who holds privileges at a hospital and provide services to patients at the hospital without being provided compensation?
Every day.
Okay. And how are you licensed? I guess my question then is, what kind of liability coverage can the hospital provide since you aren't being contracted for services, which means you're not receiving compensation? Under what provision?
Well, the hospital doesn't have a choice under the Federal Impala Act. You walk in that door, you need care, you're going to get it. They don't get a choice. Or if they participate in Halliburton, which in other words they receive federal funding for that medical facility, they have to see you. Right. There's no guarantee that you had a job, money, or insurance, and when the physician hits you in the ER and you're laying on the gurney, he's not asking for your insurance card. That happened outside. He's treating the patient, and he may or may not get compensated.
Right. So my question is not the patient, but the doctor who's actually providing the service, because under most of the liability statutes, in order to be covered by a hospital's liability coverage, they have to have some relationship with you. What relationship exists if there's not a contract for services that allows that doctor not to be subject to malpractice if he's providing services in a hospital where he's not receiving compensation?
I can't answer that question. You're by far a better lawyer than I am a legislator.
Can we find that information out?
Absolutely.
Thank you.
For my friend from Princeton and Yale, absolutely.
Thank you.
Yes, ma'am.
I think that's going to come from having staff privileges, which might be the nexus or connection, but I'm not sure. That's something we need to verify with counsel. You said you had 2 questions. You recognize for another if you want. That was 2. Okay, thank you. Any other questions? Okay, thank you, Representative Lunsford, for that stunning presentation.
Thank you, Mr. Chairman.
We're going to assign that to our Income Tax Subcommittee, and that would be Chairmans Mills, Peak, or Knight.
Thank you, sir.
Okay, thank you. Even though you're trying to hide over Representative Gordon, we're going to recognize you, and we're glad to have you.
Well, glad to be here, Mr. Chairman.
House Bill, I think, 967.
Yes, sir. Yes, sir. And if it pleases yourself and members of the committee, this is actually the second time this bill has been before the committee. It went through, I think, without any concern during the last session, but I believe due to the time period in which the bill was actually dropped by myself and going into subcommittee, it didn't. I don't think get the time it needed to really be digested by the committee, but it is something that we need. It is has got unanimous, so well, not unanimous, but bipartisan support, and basically it's been not only constituent driven, but requested by the city of Savannah, and I think just in tough times, it gives us an opportunity to send a message to the taxpayers that we do wish some tax relief amongst Georgia citizens. And basically what it does is upon someone buying a home, it requests that the local tax officials send out a homestead exemption application along with deadlines for filing. During the off season or off session, I've gotten numerous calls from folks who wanted to know is there anything they can do about their property tax. The first question I always ask them is, have you filed a homestead exemption? And probably 83% of them don't know what a homestead exemption is. What this bill does is provide the local tax officials mail out the homestead exemption application and also the deadlines.
Okay. Would the gentleman yield for a question?
Please.
Chairman Stevens.
Thank you, Mr. Chairman. Isn't it true that really once upon a time that the homeowner had from January through March, in most cases, to file their homestead exemption? Now they've got year-round, but they still don't know once they close their home until it's past the deadline for them to get that homestead exemption in.
That's true.
So they miss that first year and they have to pay an exorbitant amount of tax.
That's correct. And I'm living proof myself. I was in a home, about 2 or 3 years before I knew what a homestead exemption was. So.
It sounds like the chairman's going to be a pretty good supporter of your legislation.
Well, he's also a signer.
Oh, okay. Number 11, Chairman. The other, Representative Stevens.
Yeah, is it not true that Representative Mick Stevens, his wife, went 7 years before they found out about homestead exemption?
If the gentleman so speaks.
I think you may have ginned up another one. I don't see any other questions. That was a very good presentation, and I think legislation that's going to be interesting to debate as we go forward. Again, Representative Gordon, we're going to put it in our ad valorem tax subcommittee. That would be Chairman's Peak, Roger Williams, or David Knight. We look forward to one of those gentlemen providing you a hearing as quickly as possible.
Thank you, Mr. Chairman. Thank you, members of the committee.
Okay. I'm just going to, I guess, take these in the order now that I have. Is there anyone else? Yeah. No, go ahead if you need to go. I may just not even. Go ahead. Okay. Representative Roberts had asked me just to assign the Forest Land Protection Act changes bill, which is a cleanup on some of our Forest Land Protection Act changes, and I'm going to exercise the discretion of the chair and ask former chairman of this committee, and I think the original author of this bill, Richard Royal, who's with us here today. Remember, the purpose of first readers is for the entire committee to understand what's before the committee, so you'll have an idea before it comes up for full committee vote. So if you would, Mr. Royal, summarize for us what we know as House Bill 1028 that Chairman Jay Roberts is carrying.
Thank you, Mr. Chairman. As you may remember, in 2008 we passed the Forest Land Protection Act in the House and Senate with only one negative vote in the Senate, and then it passed a statewide referendum overwhelmingly. The administration has caused some concern to be addressed, and we tried to do this in this House Bill 1028. First of all, we define contiguous. That's a term used throughout the legislation. Secondly, we clarified that when you have property that may be straddling the county line, there was a 200-acre requirement, that if you had two covenants, the 200-acre requirement applied to both covenants. The primary purpose is forest land subject to a covenant had a provision where you could transfer property out of that to another qualified owner. Questions have arisen as to which party, should there be a subsequent breach, would pay the penalty and interest. We have clarified that extensively in here, that the breaching party pays the penalty and interest, and we've made it absolutely clear in there, and that's the primary purpose of the legislation.
Thank you. I don't see any questions at this point. I'm sure there probably will be at the subcommittee level. We're going to assign that, Mr. Royal, and I'll let Chairman Roberts know it'll be in our ad valorem tax subcommittee. Thank you, sir, very much
Thank you,
for your
Mr. Chairman.
assistance to the committee. I'm going to evacuate the chair to our vice chairman and ask him to recognize me for 5 or 6 of my own rants. Okay.
If you will, Mr. Chairman, go ahead and present House Bill 962.
Thank you, Mr. Chairman, members of the committee. House Bill 962 deals with sort of a glitch that's currently in the law. If we issue an income tax refund check, currently if that check becomes stale, that means 180 days it's not cashed. That the Revenue Department actually does not have the legal authority to reissue to that taxpayer their lawful refund, and this simply corrects that glitch in the law, so that if someone were to misplace a check or forget about it for about 180 days, this would allow us to reissue that check to that taxpayer. This bill comes to us from our Revenue Department, and it certainly is, in my estimation, very, very taxpayer friendly, almost solely. So that's going to be House Bill 962.
Any questions from members of the committee? If not, we will assign this to the Income Tax Subcommittee.
Thank you, Mr. Chairman.
Right. Next on the list will be House Bill 963.
House Bill 963 is what I'm referring to as ad valorem technical corrections bill. It's got 2 sections. The first section simply allows, for the first time ever, for electronic filing. That should be far less expensive. It's voluntary on the part. It's not mandatory to the taxpayer, but those that are able to submit and file electronically, they're going to be able to do so. We've found over time, certainly with all of our dealings with the Revenue Department, that anybody that files any kind of tax on any platform, frankly, the error rate and the ease of operations and the ability to respond in a very expeditious manner is greatly enhanced by electronic filing over paper filing. So this allows for essentially electronic signature. So under prior law, the language required that all real property returns be submitted in person or by mail, which insinuated in writing. So now we'll be able to do that electronically, and I figured far more efficiently. Section 2 of the bill cleans up some, frankly, very archaic tax provisions in our code from back in the 1950s when it was passed. It's about homestead exemptions for people making less than $10,000 a year that are age 62 and over. It was very ambiguous in the code, and the prior law actually took into account the income for the applicant's spouse, and all other residents in the home. Obviously, it was never intended to be all other residents in the home, and that's certainly been interpreted in a lot of exotic ways. So now it's just the applicant and spouse only. It cleans that up once and for all, and also clarifies that we're dealing with the net income of the taxpayer, not the gross income. Again, I think very, very taxpayer friendly from a clarification standpoint and actually a tax saving standpoint.
Any questions, members of the committee? I don't see any. At this time, we'll assign that to the ad valorem sales tax subcommittee. Mr. Chairman, if you will, your bill, House Bill 982.
982 deals with administrative garnishments, which is a collection remedy that's available currently to our Revenue Department. As you all know, we've been participating in a pilot program with several counties about augmenting efficiencies in tax collection. This bill is very much in that same vein. We currently are only able, because of staff limitations, to process 240 garnishments a year. We are literally leaving tens of thousands of delinquent accounts on the books just because we don't have the staffing or the expense that it takes now to go through the entire due process and all the formalities that it takes our department to deal with garnishments. It takes a revenue agent's personal time, typically as much as 5 hours in a day. It takes mileage at a huge cost, and there are also court filing fees that are very extensive. And we may have invested $160 or $170 in an account. We're not even able to collect that. The administrative garnishment process, we've adopted models that we've seen in Alabama, North Carolina, South Carolina, Florida, Kentucky, Louisiana, Mississippi states, very, very close to us for far more efficient ways. So that, again, when there are assets available and there are taxpayers that are able to pay their taxes, their accounts are delinquent, we're going to be able to respond to those in an expeditious fashion. 6 months from now, most times it's too late.
Any questions? Three. Is that? Go ahead, Representative.
Thanks, Mr. Chairman. Mr. Chairman, just a question in regards to the garnishments and being able to do this. Would this entail the collections now? As my understanding now is that the Department of Revenue use contract collecting agencies to collect outstanding taxes. Is that correct?
Well, this is certainly in lieu of that. This does not impact, as I understand it, the contract agencies. And these garnishments are only fileable after the final appeal by the taxpayer, as much as I think it's a minimum of 30 days after that appeal, maybe 60. But let me ask the Commissioner, he might know that specifically.
Thank you. I don't want to get you off track, but it's an important issue when you refer to, we do use private collection agencies to collect delinquent taxes. The garnishment process is separate, which is a path to try to collect things fastest. The work we do with collection agencies is different than most taxing authorities, including the IRS program that was turned off, I think, last year or the year before, where they were just giving past due tax obligations to collection agencies. We only use them when a lien has been filed against the taxpayer. So the agency is only seeing the taxpayer name, address, and tax type, and the dollar amount. They don't get to know the taxpayer's personal information. And that was the difference between ours program and the other. So the garnishment process would start in conjunction, but be separate from that. But there is a distinguishing difference between our program and others.
Thank you, Mr. Chairman. I was just trying to get some clarity on that.
Well, thank you. That was a good question. I'm glad you did, because now I have it. Thank you.
Thank you, Commissioner. Thank you for your questions. We are going to assign this to the Public Finance Subcommittee.
Thank you, Mr. Chairman.
Chairman, House Bill 983.
Ladies and gentlemen of the committee, this legislation is, again, part of that entire package that I'm bringing before the committee and hopefully the whole House this year, so that we can more effectively collect legitimate taxes that are owed to the state of Georgia. And this has to do with captive factoring companies. When we see these devices, I might call them, that are concocted by very clever tax planners to essentially shift income that's generated in Georgia out of Georgia, I call that gaming our system. You all were kind enough last year to analyze with me and help us pass a bill that we dealt with captive REITs, if you remember that terminology. We had a fiscal note last year that estimated that might generate as much as $14 million in new taxes. Captive REITs are very much like captive factoring companies, except what factoring companies do is that they sell at a deep discount in some cases to their own captively held companies out of Georgia their accounts receivable, so that they essentially are artificially discounting their own accounts receivable under a more favorable tax treatment. But I want to close the loop back on the REITs. We thought maybe $14 million last year, and you all helped us pass that. very, very technical legislation on captive REITs. We have actual data that supports in 2009, after we passed that legislation, in 3 cases only, 3 single cases, as bad as our budget is. Imagine without the REITs legislation, we have $78 million less than we do. That's what we collected from what you did last year, where our system was being gamed. That was 3 cases. Commissioner, we commend you for that, the entire Revenue Department for that. A great job, and we're expecting even better things this year from the REITs, and if we are successful in the captive factoring, I expect similar outcomes from that. Again, this is not a new tax, it's not an additional tax on companies, but we're just tired of sitting by and letting ourselves get gamed by clever out-of-state connivers that are coming, that aren't paying any part of our infrastructure, yet they're taking income and using our markets and taking them out of state. And this is prong 2 of our assault on them, and I hope they know they're not going to be welcome here long.
Any questions? All right. Mr. Chairman, we'll assign House Bill 983 to the Income Tax Committee. Next bill, Mr. Chairman, House Bill 984.
House Bill 984 is very simple, very straightforward bill. There's actually a code section currently in our code that allows our counties independently to establish an income tax countywide. I just can't imagine the confusion that would cause if we had counties imposing specific income taxes within their own county borders as it would relate to inter-county or interstate or international business. But it's been in the code section for years and years and years. I don't think it's ever been utilized. It's couched under what they call reasonably attributable property owned and business done within a county or a city. I see those kind of interpretations as being very dangerous over time. And as far as continuity or unity, so to speak, in the understanding of tax laws, I just see that as a train wreck about to happen. So House Bill 94 just simply abolishes the income tax at the county level. We don't have it in existence anywhere, but it abolishes the possibility of that.
Any questions? Chairman Stevens.
Mr. Chairman, is it possible already, I think whenever we revised the business license, when we went to a different sort of tax, don't they have the ability to tax on income for a business license in a city?
In effect, they do. It's in the formulas on how they establish the occupational tax. So in another way of explaining that, in effect, that they do. But this is a pure income tax, like Georgia has over $10,000, 6% of our income is taxable.
Individual income.
This would be a 1% county income tax on just the residences that live in that particular county. So in addition to the occupation tax, in addition to all the other ad valorem tax, in addition to franchise fees they already pay or franchise taxes, and in addition to insurance premium taxes. So it would be just pretty well egregious to allow that to be established, in my opinion.
Any further questions? Mr. Chairman, we'll assign House Bill 984 to the Income Tax Committee. And the last bill you got here is 986.
Thank you, Mr. Chairman, and thank you for saying it's the last bill. And thank you all very much for your attention up to now. This is the electronic data match with financial institutions bill. Again, this is a bill that's going to give us and it's voluntary for the banks to participate in this, completely voluntary program. But it's a way that DOR will have the opportunity to identify deposits in all of the banks in Georgia, rather than having to go through a lengthy due process notice and essentially just a sort of a random hunt to see if there's any accounts anywhere to satisfy bad tax debts. One of the biggest criticisms we've had in the collection, for instance, of sales taxes is that we're unable, because of resources as well as manpower, to respond quick enough to fiduciary tax defaults. The same is true here with the electronic data match in financial institutions. If the banks voluntarily and they have to, they can be subpoenaed for this information anyway, as I understand it, Commissioner. And it gets irritating to where DOR has to just subpoena bank after bank after bank, hoping that they find where somebody has an account. This allows the banks to voluntarily be involved in it so that they don't have to answer all these inquiries where they really don't have an account. So with the data match, if they have an account, it just makes it more efficient for our banking institutions, as well as the DOR to locate whatever tax delinquencies or whatever are out there. Again, it's part of the overall package. We're absolutely dedicated to the proposition that we're going to enhance and augment our ability to collect taxes that are due the state of Georgia legitimately. That way we can all pay less someday, I promise you, but it's not until everybody pays what they have to pay that we'll be able to do that.
Any questions?
Will there be any, I understand with the subpoena, then they are mandated to turn over those records, but absent that, they may have some privacy restrictions, maybe federal privacy. Will this get the bank around violation of those privacy restrictions?
Oh, it absolutely does. And this is only after that all of the appeals are exhausted. This is way into the process. This is kind of the end of the line. But yes, it will protect all those confidentiality at federal law levels as well. Commissioner, would you like to speak to that?
Thank you for your consideration of this. Part of what we're getting at is to make it clear that it's an authorized methodology for us to use on a voluntary basis. The other way to look at it, too, if you're on the bank side, and I've been the CFO of a community bank before, and we would get dozens of these type of record requests from the FBI, from the Justice Department, from IRS, from the state, allowing us to deliver that to them electronically and let them sort it like they want, if those that want to participate, is more efficient than each one of those coming to you by FedEx or certified mail or by Marshall delivery service that they have to sign for and research one at a time. It ties up branch time, it ties up administrative accounting time, where those that want to go through this process, and it is being used in other places in the country. But the design is to be a less burden on both sides, but to make it clear that it's an authorized procedure for them to elect to use, which gets to the heart of your question too, which is what one of the banks had asked us for before.
We ask a lot of our community banks, ladies and gentlemen, and if we can simplify their lives, they've never needed us to help more. And I only mean that in the most complimentary way. I'm very proud of our banking system, but they've had some hard days, as has most of citizens of Georgia.
Any other questions? Mr. Chairman, we'll assign that to the Public Finance and Policy.
Thank you, Mr. Chairman. Thank you for taking over. We've got still some other bills to do. Appreciate I think I saw Chairman Willard come in. Are you in the room with us? If you don't even want to, I'll assign that. We've already passed it 13 times. But if you want to tell us about baseball arbitration.
We're making the governor happy. I think I can tell you, lost, local option sales tax, baseball arbitration. Any questions? We passed this bill last year all the way to the governor. The governor was unhappy because a part of the local option sales tax statute that he had inserted back in the early 90s was not coming forward in the new bill, and I can point you to that part of it. It's paragraph 5, beginning at line 95 on page 3. This is what I call the doomsday provision, so that if you don't have something done within a period of time as far as a new agreement, there will be a stopping of the tax. And I think, Mr. Graves, you had some concern I was removing it last year. The reason it was removed last year is because we have a certainty that there will be an agreement reached by the fact that there will be this arbitration that brings resolution between the parties. But the governor still felt he wanted to have that in there, and Mr. Graves, I think, made a great stand on that principle, and so I put it back in the bill.
Thank you for that. We're going to assign that Chairman Willard back to the sales tax subcommittee, but I'm sure it's going to come out of there pretty fast.
Thank you so much.
We'd like to get that done for you as quick as we can. Thank you, sir, for coming.
Always glad to be with you.
Well, we're honored to have you here, too. Thanks. Okay. Representative Flood, You recognize that's your seat. Please, sir, if you would tell us about House Bill 985.
Thank you, Mr. Chairman. House Bill 985 is actually a repeat of Senate Bill 25, which the Senate passed last session unanimously, except they failed to read the Constitution, which says all tax bills have to be originated in the House. So this is now the House version of a bill that passed the Senate unanimously last year. It essentially gives Georgia taxpayers the option of choosing to contribute money to the Multiple Sclerosis Society by using their state income tax as a checkoff option. Multiple sclerosis is a neurological disease that affects the muscular, major motor functions of individuals. It's an incurable disease that affects about 9,000 Georgians, and this simply gives Georgia citizens an opportunity to contribute to the education and funding of issues dealing with multiple sclerosis by making a contribution to through their state income tax.
Certainly a laudable undertaking, and I don't see any questions. We're going to assign that to our income tax subcommittee. Representative Flood, that would be Chairman's Mills, Peak, or Knight, and we look forward to the debate on that. That's a very good proposition, I think. Representative Graves is here to tell us about House Bill 1024.
Thank you, Mr. Chairman. This I'm going to bring on behalf of Representative Scott, who had some business to do back in the district. This is the sales tax deposit phase-out that we had last year in the jobs bill, and as well this year it is sort of in tandem with House Bill 1023, which is another portion of the Jobs Act of 2010. Gradual phase-out of the sales tax deposit over, I think it's a 3-year period, benefiting the smallest businesses first by refunding back working capital that they've put on deposit with the state of Georgia, and instead of refunding it back to them so that they can meet payroll, buy more inventory, and advance their business.
Thanks, sir. Any questions? I don't see any. That's going to go to our sales tax subcommittee. We look forward to the debate on that issue. We learned a lot about it, I think, last year, so it shouldn't be that much of a new concept. Thank you very much, Chairman Graves. Representative Taylor, are you with us? If you turn your light, I can tell which one to turn on. You're recognized, please, sir, for House Bill 992.
Thank you, Mr. Chairman. House Bill 992 simply offers an income tax credit for expenses related to private security. Private security expenses that homeowners spend up to $1,200 a year. About $100 a month is what I figured. It's becoming more and more popular in Metro Atlanta, particularly in the city of Atlanta. I guess everybody can hear me. In the city of Atlanta, there are a lot of neighborhoods, homeowners coming together, hiring private security to patrol their neighborhoods in the evening into the morning hour.
Excuse me, can I stop you there? Can everybody hear the gentleman? We've got a ringing that we had to turn his microphone off out of no disrespect. If y'all can hear him and you want to go ahead, or you can use the one next to you, whichever you prefer. Is that 14?
Yeah.
Let's try that and see if that's better.
Is that better? Much better. Okay. But it's a growing thing that's happening, particularly in Metro Atlanta. I mean, we have a serious crime problem in the city. There are a lot of homeowners, neighborhoods where homeowners are banding together, hiring private security to patrol the neighborhoods at night and into the morning hour. DeKalb, Fulton, Clayton, Cobb, Cherokee, and Gwinnett. In particular, here in the city of Atlanta, there are over 60 neighborhoods that have done this. I represent a lot of them. Over half the neighborhoods in Buckhead have them, but also lower and middle income neighborhoods all across the city are doing it. The neighborhood I used to live in, the West End here in Atlanta, I was a part of it, and I paid about $45 a month. My current neighborhood, Washington Park, where we just had our second murder of the year a few weeks ago, we are talking about doing it, and it'll be about $55 a month because we have fewer homeowners in this neighborhood. One example of how it's been really successful in one of my neighborhoods on the north side, Peachtree Battle, one of the off-duty police officers when just patrolling the neighborhood one night, did a random stop of a guy, and he happened to be the Buckhead rapist. And he was arrested, tried, convicted, and is now sitting in jail, and it was all because of private security. So just a simple way to give some folks who are trying to take more personal responsibility for their homes and their neighborhoods just a little help from the state.
Okay, thank you, sir. I don't see any questions, and we're going to be assigning that to our income tax subcommittee. And that would be Chairman James Mills, Alan Peak, or David Knight. We look forward to further debate on that issue. Certainly not last but least, Representative Black. Tell us about House Bill 971, if you would, please, sir. What? There we go.
971 gives the Revenue Department the option. If they owe a refund to taxpayers of this less than $1, they will not have to refund that unless the taxpayer requests it. If the taxpayer requests it, they would have to refund it. It also has a provision that says if the taxpayer owes less than $2, they're not going to bill him.
I think that's certainly a laudable undertaking. Any questions? We do kind of get to where we challenge materiality sometimes, don't we? That was a pretty succinct explanation, too. I want you to know we appreciate that. We're going to assign that very laudable undertaking to our income tax subcommittee. That's Chairman's Mills, Peak, or Knight, and I hope they'll get to work on that for you very quickly. Representative Peak couldn't be here today, but we've got House Bill 1008 and 1014. Both are going to be assigned to our sales tax subcommittee. I don't see Representative May. Is Representative May here, and I'm missing seeing him anywhere? He has House Bill 996, which we're going to assign to our ad valorem tax subcommittee. Are there any other members here that have any further business to bring before this committee, or is there anybody with any other first readers? I don't see any further business. I want to thank the members of the committee for being here. I want to encourage our subcommittees. I know we're under the budget crunch with appropriations, but you can see by just the number of propositions we assigned today, we've got a lot of work to do. That's the reason we have 3 chairs of each subcommittee, and I encourage you all to get on with these meetings. I think we have a lot of very important legislation in the committee that we need to deal with and vet in a very comprehensive and detailed way. And I say that knowing everybody has responsibilities to our appropriations process as well. So looks like there's going to be some late nights, but I want to thank each member of the committee that could find the time to be here today. It's a great turnout. It really is, and I appreciate each and every one of you. If there's no further business to come before the committee, we stand adjourned.